All right, so is it power tussle versus the law now? I guess we'll find out. Let's head to Abuja. Okay.
Well, thank you, Chamberlain. We're looking at Section 11 of the Nigerian Constitution this morning, subsection 4, which says that at any time when the House of Assembly of a state is unable to perform its functions by reason of the situation prevailing in that state, the National Assembly may make such laws for the peace, order, and good government of that state with respect to matters on which a House of Assembly may make laws as may appear at the National Assembly to be necessary or expedient until such a time as the House of Assembly is able to resume its functions, and any such laws enacted by the National Assembly pursuant to this section shall have effect as if they were laws enacted by the House of Assembly of the state. The question is, are there any conditions for this to happen? Joining us this morning is Professor Tahir Maman Owen, who is a senior advocate of Nigeria and former Director General of the Nigeria Law School. You're welcome to Sunrise Daily.
Thank you. My pleasure.
Well, you have seen the circumstances, and it looks like this section of the law is about to be given effect, even though we understand that there are certain conditions that the National Assembly has put in place, saying that it is if they are not met that this section will be activated. What do you make of the imbroglio so far, and do you think we're where we should be activating this section?
Well, thank you, Maupe. What is happening in Edo and the attempt by the House of Reps to intervene is a clear example of the Constitution as a political document. It's both a legal and a political document. And it envisages a situation where, because of one reason or the other, essentially crisis, the state assembly is unable to perform their legislative functions for the National Assembly to intervene. And the law says a National Assembly, not just one arm of the National Assembly. Because what constitutes lawmaking is the two arms coming together and then going through the usual processes. And
that's an interesting point you make, because I think even in previous times where we have seen that the National Assembly has taken over, it is usually the House of Representatives. So if one is not careful, you would actually think the Constitution stipulates for the House of Representatives, unless there's been some shuttling of duties in the National Assembly itself. What we have seen oftentimes is the House of Representatives taking on that position.
Yes, they took the first step. But as you know, the Senate has already set up a committee and is looking into the matter. Okay. And it is actually a contingent, temporarily power donated to the National Assembly to look after the affairs of a state, legislative affairs of a state when there is a crisis. And as I say, it is contingent, sort of temporary, because if you look at the second part of the Constitution, which says the state assembly cannot be said to be unable to perform the functions of its office if it can hold meetings and transact business. Now, so the undercurrent is that the assembly, as you have heard, the speaker, the current speaker says, the law is on their side. They've constituted their leaderships. With speaker emerging, they had a quorum, because the quorum under the Constitution is it's a 1/3 of all members. And from what one had, you know, they had about 9 people. It's not the best situation, obviously, when you have a house about 24 people for 9 to sit. But that is the crisis anyway. That's what led to the present crisis. Now, those conditions given by the House of Reps and their approach, with due respect, could actually complicate matters. Yes, it could, because it's like simply adopting the position of the other side to the fight. That seems to be the position. And I don't see anything in the Constitution which provides for all those things they are talking about.
Yeah, so they, I mean, if you follow the story, there were allegations that the quorum wasn't even properly, the House wasn't properly inaugurated. The inauguration was done at night. I mean, we even saw House members were dressed to the occasion. It didn't look like, it looked like something that was hastily conducted from how some of them, were dressed. And then it was under very, we hardly see houses being inaugurated at 9 p.m. or, around 10 p.m. That looked a bit strange. Now, they did say that, I mean, if you listen to the other side, they said, oh, they had been waiting for the other members since morning. And it was after they had waited and waited that, oh, that was why they had to go ahead anyway. But if you look at this entire situation, can we really say that it was properly done? Doesn't it warrant the House to say that a fresh proclamation, if indeed this is about good faith, a fresh proclamation be done and all members be inaugurated?
Well, in law, there are two things, issues of moral, propriety, and legality. It is not in all situations that what is legal is necessarily moral, or what is moral is necessarily legal. What you have said are very untidy situations. This is actually what led to all this crisis. But they don't make them the entire exercise illegal. It doesn't run illegal. What is a bit problematic to me there is when you issue a proclamation, 10 days is not a problem. Although the Constitution says immediately a governor is sworn in, proclamation is to be issued, but you can spend the whole day interpreting what is immediate after being sworn in. In any case, the Edo State governor wasn't elected in the last election.
Yes, he's been there for a while.
Exactly. So what I suspect is that delay was really led by the crisis, the inability of the House to, or the problem between the various power brokers, to put together some kind of compromise. So that led to the delay. But there's certainly a problem with lack of time in a proclamation. If the House is going to sit, there has to be a time for its sitting. And I imagine they have time for legislative business. Although they can also regulate, they can always regulate all these things. There's nothing black and white specified there.
How could they have regulated when they had not been inaugurated?
No, certainly not. But the sitting itself, couldn't have been such a huge problem if that consensus was there. It is the absence of this consensus which have led to all these things. But in terms of the legality of all the things that has taken place is problematic actually to impeach it. But it is not proper, that's just it, because you should have kind of consensus. And that is what I really thought the House of Reps should work towards. Their power technically is to make law, okay? But, as political leaders, when there's a problem, go behind the scene, the way probably the Senate is approaching the matter, and broker some peace so that all those things which the House of Reps, directed could be achieved through some kind of negotiation. Not as a directive, because the Constitution doesn't provide for that. That's really what they could have done through, try to bring the parties together and that sort of thing, and then broker a consensus and an agreement.
Well, one of the parties says they're not surprised. I think it's the Speaker of the House that has issued a response saying that they're not surprised that this is the decision that the House has reached. They allege that they were biased in the first instance, and they also say that they have a court injunction, barring anybody. No, I don't know. I'm not aware of the details of that court injunction, but they say they have court injunctions barring any further actions on the state of the Edo State House of Assembly. Do you see a role for the courts here?
Oh yeah, the courts have powers, both express and inherent in their jurisdiction to intervene in any dispute that may arise. And it's an appropriate forum actually to go and ventilate the issues, and then whatever the court decides eventually, the parties can fall back on that and come up with a solution. If the godfathers of Edo politics cannot come together, and resolve this matter, to me, it's a shame actually.
Okay, but we have there are other members of the House who were legally elected. They are waiting to be inaugurated.
That's right.
What should be the fate of those people?
Well, they continue to be members-elect, but they cannot begin to exercise the powers of members of the legislature until they are sworn in. That is the problem. And why they were not sworn in is what we don't know. You know, it's the issue of the time you are talking about, but they are there as members, certainly. They've been given certificates of return and everything. They're members-elect. So they just wait for all these crises to be solved, and then they go there and be sworn in again and continue to participate as members of the House.
So you don't think, I mean, a situation whereby majority of the members have not been sworn in. This was the swearing in that happened,
okay.
I think, at that time of the night. Interestingly, we're not able to get the full shot of some of the members, but that's the swearing in situation. Now you have majority of them who have not been sworn in. You think it is explainable that majority of them were not there as at the time when that activity took place?
It is not, but that's a symptom of the crisis. Because it's very clear there was an attempt, an effort to exempt, to knock out some people, because if they are there, probably they have their own arrangements for different leaderships, and they belong to another faction, and they attribute that to the faction of people in Abuja, whoever they are, whereas the 9 members, who eventually who constituted the leadership, are those who are there in Edo. I remember too, the same thing played out in Bauchi.
Yes, indeed.
Yeah, I'm even surprised.
And then those ones, they didn't wait they went and swore themselves in right in front of a mace that was right in the premises of the State House of Assembly. Would that be legal? I mean, then the question would arise as to which one of them do you accept as the legal one?
That's a dummy mace. Well, I don't know. That's enough for, I believe, even there too, I believe the courts are going to sort that one out. Yeah.
Well, in the meantime, how would you say that this be resolved?
It has to be a political solution, unless the courts intervene. These are the 2 mechanisms through which the problem can be solved. Through the political gladiators sitting down, because, as Eisenhower said, there's only the middle ground is where the road is. The other sides are actually gutters, which means the oil of politics, and generally any decision making is compromise. So the moment people take extreme positions, you are really going in for impasse and complete stalemate. And no decision will be taken at all, and then the state will continue to suffer.
What would be compromise in this instance?
Well, the politicians have a way of sharing positions. The whole thing has to do with, okay, who is going to produce the leadership? Going back to the 2 states, actually, but especially Idona, that's what we are talking about. It has to do with control of the House. Leadership is not other principal officers. And there's a way that can be sorted out, as it has happened in National Assembly. And if the major, players can understand that, look, it is the interest of Edo people that is at stake. Their own name is also, at stake, because if they cannot agree on the way to manage just one state, the affairs of one state, I don't know what claim they can have to national leadership in any way, or leadership in any political setting. So
that's very instructive.
Yeah, so they should actually be required to go back. The national chairman and the state governor, they should be able to sit down and sort out this matter. Or they just allow the matter to go to court, and then whatever the court eventually comes up with, then that has to be the decision. And but as you can always see from the Nigerian setup, they take all this matter out to the Supreme Court, in which case the affairs of the state will continue to suffer, or the National Assembly now can now legitimately come in where there's a need for law to provide for peace, good governance of the state, then they can now intervene. And the Constitution, as I said, is very clear and particular about the role of the National Assembly on this. That's why even the governor cannot be removed, his deputy, they can't do that. And then again too, if they can secure the State Assembly in such a way that even that number can meet, then with some kind of arrangements or consensus, they should be able to come up with a kind of decision. Because if you look at the Constitution, it says the House of Assembly will not be said to be unable to perform the functions if it can hold meetings and transact business. So what actually stopped causes impasse at the moment is the security component of it, which prevented the House from meeting. If they can meet, they'll be able to transact business because they will have the quorum.
Yeah, but if the other group decides that we are also a majority and decides to inaugurate themselves one way or another through some access, you know, it might be questionable. But and, you know, which one then, which faction would we be saying is the authentic State House of Assembly?
The foundation for inauguration is the proclamation.
Yes.
So if they do not have a proclamation of the governor, there is nothing they can do.
Well, you did say that there was no date or time stipulated for that proclamation. Doesn't that then put it in, you know, under very strong question? Because at the National Assembly where that happened, what they relied on was the fact that that proclamation had a date. It also had a time. They relied very heavily on the fact that the president said by 10 a.m. They did not understand where their other members went to, when the time for that proclamation was due. Yeah,
that was the issue in 2015.
So if indeed a proclamation was issued and there was no time or date stipulated for it, can they say, oh, we too have now decided that this is when we found it convenient, and they inaugurate another house, so to speak? Wouldn't that be a little dicey in the eyes of the law?
They still cannot do that because that proclamation, the only institution that can impugn or make a decisive position on it is the courts. Whether a proclamation that doesn't have a day, timing, that doesn't have time and venue for sitting is valid, you know, can only be decided by the courts now, not an individual interpretation of it, whether they are members elect or any other person.
You know how these things happen.
Exactly.
I'm not putting ideas anywhere, but these are scenarios that, you know, we saw what happened in Bauchi, for instance. In Bauchi, the situation was that the members claimed that the time which was stipulated for sitting had not yet reached. And the members were already in the chambers inaugurating another assembly. So, I mean, in these scenarios, you are a lawyer. Do you see the importance? Is the time going to be a necessary component and ingredient of proclamations?
It will be when it goes to court. But as I said, the individual members cannot inaugurate themselves. They don't have any other proclamation because the fact that may appear to be, it is still the proclamation for now until the courts make a ruling on it. And if I were in that camp, that's what actually they should be doing. Instead
going to the courts?
Yeah, going to the courts to determine the status of the proclamation. And then that's a shorter cut, actually, you know, apart from the political solution, which seems to be getting almost impossible. But that is the most legitimate step to take.
Let's go to Lagos now and see whether we have another perspective waiting. Gentlemen.
Professor, I was just wondering, in the law, the Constitution says that
the governor or the executive has to transmit a letter to the legislature before they are inaugurated. Now, in the same constitution, the legislature comes before the executive. So if the legislature has to wait for a letter from the executive, doesn't that presuppose some dependence of one on the other, and one be more powerful than the other?
Well, not necessarily so. You know, these arms are supposed to complement themselves. And not living complete autonomy doesn't mean one arm not having anything to do with the other. And the problem is a house, the life of a house comes to end, you know, at a particular time. And so once that ends, there's no other body or institution again that can bring it to life except another existing institution. And that's why the Constitution provides that a governor or a president, once he is sworn in, you know, will not issue proclamation. So this is it. So there's some level of dependence. I remember too, the president and the governor cannot begin to perform the functions of his office unless he takes the oath of office, and which is administered by the chief judge in the case of the governor, and the chief judge of Nigeria in the case of the president. So there is this interdependence, you know, amongst arms of government. But the moment they are sworn in, they take that oath of office, you know, they assume their own individual entities. They become individual entities and begin to perform, enjoy their autonomy. So that's not a problem at all.
This other angle that which you mentioned the other time, and it's probably looking more like a technicality in the Constitution as opposed to the facts in the situation, because you know the Constitution says that the letter should be transmitted as soon as the governor is sworn in. But in this case, from what the members of the House of Representatives Committee found out, took place 10 days. Now, you said the other time that that's neither here nor there, but isn't that a technicality of law that needs adjustment?
Well, it says immediately a governor is sworn in, he will not issue, he's entitled to issue a letter of proclamation. And in the case of Edo, the governor didn't participate in the last election, so he was in office. Now, what I suspect is that this delay was occasioned by the problems, you know, which prevail in the state, and the attempt by the power brokers there to broker some kind of solutions as to the leadership of the House of Assembly. And 10 days ordinarily shouldn't be such a big issue if that consensus is there, you know, as to who will manage the House. And because the Constitution didn't specify a particular date other than to say period, other than to say immediately after the governor is sworn in. And as I have said, even in this case, the governor wasn't sworn in. So he could have issued it actually the following day, you know, in the spirit of the Constitution. But that wasn't done because of the underlying problems in the state. And, but the key issue is, as we have mentioned here, the lack of time there, which means a problem of communicating with every members. And even when the Assembly had its first sitting to elect its leadership, that suggests some kind of bad faith in the entire transaction. And, but that isn't to say the proclamation itself is not legal, as it is, subject to whatever the court may interpret it by. As it is on the face of it, it is really not an illegal instrument.
So well, it's a fine place to leave it, Professor. We have to thank you for your insights into this issue. Professor Tahir Maman, OON, is a senior advocate of Nigeria and a former Director General of the Nigeria Law School. Thank you again for coming on Sunrise Daily. The program continues in a moment with another perspective. Please stay with us.